All right. Good morning, everyone, and welcome back to the Granite Files, where we have been investigating the County of Henrico intentionally polluting our drinking water with a chemical called hydrofluorosilicic acid. The common name for this is fluoride, but this isn't the type of fluoride that you would find in the mountains of the Appalachia. No, this type of fluoride is a recycled hazardous waste byproduct that comes from the fertilizer industry. It has a pH of about 1.2 and can eat through concrete and metal. Those within the EPA scientists say that this is a dangerous pollution that should never be in our drinking water. So, why is the County of Henrico intentionally polluting our drinking water? Well, one of the many reasons that Henrico County has given to me is that they are forced to pollute the drinking water because it is a condition of the waterworks permit. Yes, you heard that right. The County of Henrico claims that the waterworks permit that they have requires them to intentionally pollute our public drinking water. Now, I was shocked by this assertion back in, I would say, the early 2025. It was when I was speaking with the Public Utilities Director, Bentley Chan, that I learned that this is what they believe. So, as opposed to just taking Bentley Chan's word that he's forced to pollute our drinking water as a condition of the waterworks permit, I did a records request so I could see the permit for myself. And, well, to my surprise, the waterworks permit does not require the County of Henrico to pollute the drinking water. Quite to the contrary, it expressly states that they need to do everything in their power to mitigate types of pollution in the drinking water. So today's video is going to be for everyone, but I hope that the waterworks operators can follow along with me because you're required to obey this waterworks permit. And I would hope that the Department of Public Utilities Director Bentley Chan, the County Manager John Vitulkas, as well as the Board of Supervisors also take a close gander at this waterworks permit along with me to understand that what you are doing is actually violating the conditions of this waterworks permit. So, as opposed to me just saying it out of the word with the words out of my mouth, how about I show you and you decide for yourself after reading the waterworks permit and reading the state law and the regulations that is connected to this waterworks permit. Okay, so let's get into it, shall we? All right, everyone, we are now looking at the County of Henrico's waterworks permit. At the top, it says Commonwealth of Virginia, Department of Health, Office of Drinking Water. This is the waterworks operation permit. Okay, so Bentley Chan said he is legally required to follow the waterworks operation permit. Now let's see if this permit requires the County of Henrico to pollute the drinking water with the FDA-defined chemical drug hydrofluorosilicic acid. Okay, that is what we are trying to track down. Does this waterworks permit require Henrico to pollute the public drinking water? All right, let's take a gander. Henrico County Department of Public Utilities is hereby granted permission to operate a Class 1 community waterworks, having a design capacity of 80 MGD at Henrico County Water System located in Henrico County in accordance with, and this is important, Title 32.1 of the Code of Virginia and the waterworks regulations, this is important, of the Virginia Department of Health. That's going to be 12 VAC 5-590. This permit is issued in accordance with previously issued operation permits number 4087125, issued on February 10th, 2005, and number 4087125-P, issued April 15th, 2009, with accordant and with the understanding that the owner, that's going to be Henrico County, understanding that the owner will operate the waterworks in accordance with, this is very important, guys, with Part 2 operation regulations for waterworks of the waterworks regulations of the Virginia Department of Health and any variants or special requirements noted below. This permit does not suspend, minimize, or otherwise alter the owner's obligation to comply with applicable federal, state, or local laws and regulations or permits. Okay, so that is a lot. So, in other words, Henrico County is the owner of the waterworks. Okay, this is a county waterworks. Bentley Chan does not own the waterworks. John Vitolkis, the county manager, does not own the waterworks. This waterworks is owned by the county of Henrico. And as the owner of the waterworks, Henrico County is legally obligated to obey Title 32.1 of the Code of Virginia, as well as the Waterworks Regulations 12 VAC 5-590. Now they go on to say again that they issue saying that the understanding of the owner, meaning Henrico County, will operate the waterworks in accordance with Part 2 operation regulations for waterworks. And this is really where we want to put a lot of focus in on today, is going to be Part 2 operation regulations for waterworks. Does this section require Henrico County to intentionally pollute the drinking water with hydrofluorosilicic acid? Okay, now this permit specifically says that no matter what this permit says, it does not suspend, minimize, or otherwise alter the owner's obligation to comply with applicable federal, state, or local laws and regulations. And the reason why they do this is because Virginia Department of Health's Office of Drinking Water, they cannot be liable. Right? So essentially this permit says it doesn't matter if Office of Drinking Water tells you to put drugs in the drinking water. It does, just because VDH recommends putting drugs in the drinking water. Look, folks, we may have recommended it, but the obligation to figure out if whether or not what we recommended it is compatible with state and laws, it's the responsibility of the owner, okay? So in my opinion, this is very sinister because the waterworks operators in the county, they look to Virginia Department of Health for guidance. And Virginia Department of Health says, look, no, folks. It is the owner's responsibility to know what is lawful and not lawful. We can give you guidance all day long, but we're not legally responsible if you follow our ill-advised guidance. You are responsible for following the state laws, the Federal Safe Drinking Water Act, and local ordinances and so forth and so on. It says applicable federal, state, or local laws. Local laws is going to be ordinances and regulations or permits, right? So let's take a gander because the Department of Public Utilities director believes that this waterworks permit requires him to pollute the water. Now, if you are a waterworks operator, you are required to obey this permit, right? And so if you are not if you were violating this permit, I would imagine as a waterworks operator, you could be in trouble, possibly, right? Because you're not protected. You don't have qualified immunity if you are breaking the law, right? So let's figure out if Henrico County is violating the state laws, and specifically Part 2 operation regulation for waterworks. I want to start here on Part 2 operation regulations for waterworks. So let's jump into that, okay, guys? Everyone, let's see if this waterworks permit actually requires the County of Henrico to intentionally pollute the public drinking water with hydrofluorosilicic acid. Let's jump on to Chapter 590, Waterworks Regulations. This is the LIS website that has all of our state laws and all of our regulations. So we're going to scroll down to Part 2, which was what was listed in the waterworks permit. Okay. Here we go. This was the specific language in the permit. Part 2, operation regulations for waterworks. Let's see if any of these 3 regulations actually requires the County of Henrico to pollute the drinking water with hydrofluorosilicic acid, commonly referred to simply as fluoride. So let's look at the first one. Okay, this regulation is going to be 12 VAC 5-590-340 compliance regulations. The VAC here, guys, just means Virginia Administrative Code. This is not state laws, these are regulations, okay? And these regulations we also call Virginia Administrative Code. And this particular regulation just refers to sampling and testing. If you scroll down a little bit further, they list some contaminants of concern. So we have arsenic, we have asbestos, barium, beryllium, cadmium, cyanide, mercury, and right in between cyanide and mercury, we have fluoride, okay? Now, let's just use a little bit of common sense just for a moment. It's inconceivable to imagine the County of Henrico going out of their way to purchase cyanide and intentionally add it into the drinking water, right? If they did that, they would be psychopaths. It's equally inconceivable to imagine the County of Henrico intentionally purchasing mercury and putting it into the drinking water. We would think these folks are psychopaths. Now, we get to fluoride. Fluoride damages the brain, it damages the bones, okay? And the County of Henrico has been provided with this evidence, and yet they continue to put this in the drinking water. I believe that that is psychopathic behavior, in my opinion, okay? Now, we're not discussing whether or not this is psychopathic behavior at this point. We're just trying to figure out if the waterworks permit requires the County of Henrico to intentionally pollute the drinking water with hydrofluorosilicic acid, commonly referred to as fluoride, okay? So as it stands now, this first regulation does not require the County of Henrico to pollute the drinking water with hydrofluorosilicic acid. But we've got 2 more regulations, so let's see. Okay, here's the second regulation. Okay, we're going to be looking at 12 VAC 5-590-330-350, which is assessments and sanitary surveys, right? 12 VAC 5-590-350. And I would like to draw your attention to the last part of this first paragraph that says every effort shall be made by the owner to the extent of his jurisdiction to prevent the degradation of the quality of water supplies. The owner in this case is Henrico. So to put it plainly, this regulation requires the County of Henrico to make every effort possible to prevent the degradation of the quality of water. Now, that means, to put it plainly, they must make every effort possible to prevent cyanide from going in the water, mercury, arsenic, and fluoride, right? So, hydrofluorosilicic acid is a recycled hazardous waste byproduct. This is actually a type of pollution. And so this regulation requires the County of Henrico to do whatever they can to prevent different types of pollutants from going into the drinking water. Okay, so remember, the question is, does the waterworks permit require the County of Henrico to pollute the drinking water? Does this regulation require the County of Henrico to pollute the drinking water? No, this regulation does not require the county to pollute the drinking water. It requires the County of Henrico to do everything in their power to prevent pollutants from going into the drinking water. Okay, but remember, we've got 3 regulations, so let's see if the last one requires them to put it in the drinking water. No, we've got 12 VAC 5-590-360 responsibilities of the owner. The owner is Henrico County, and specifically, I want to draw your attention to the last part of this first paragraph, and it says preventive control measures identified in part 2 of this chapter shall be promptly implemented to protect public health. Okay, now, if you go out of your way to purchase a recycled hazardous waste byproduct and intentionally put it into the drinking water, you are not protecting public health. You're actually harming public health. Remember, fluoride is not a nutrient. Fluoride damages your brain and fluoride damages your body. Okay, so I think it's fair to say that the waterworks permit does not require the County of Henrico to intentionally pollute the drinking water with hydrofluorosilicic acid. In fact, quite to the contrary, the regulations require them to do everything in their power to promote pure water, to promote the potability of water. I do want to point out one more thing, though, because a viewer did ask, well, what do you mean by degradation of the quality of water? And luckily, the Virginia Administrative Code has definitions. So I want to remind you guys what pure water means. Pure water means water fit for human consumption that is sanitary and normally free of minerals, organic substances, and toxic agents in excess of reasonable amounts, and adequate in quantity and quality for the minimum health requirements of the person served. It is not reasonable to intentionally add the toxic agent hydrofluorosilicic acid to the public drinking water because it is not used to promote pure water. It's used as a preventive medical treatment, okay? So it is not reasonable to put hydrofluorosilicic acid into the public drinking water. Let me skip over to the next part that I wanted to show you guys. And it says here under definitions, pollution means the presence of any foreign substance, chemical, physical, radiological, or biological in water that tends to degrade its quality so as to constitute an unnecessary risk to human health or impair the usefulness of the water. Okay, again, pollution means the presence of any foreign substance, And foreign substance can be chemical, physical, radiological, radiological, or biological in water that tends to degrade its quality so as to constitute an unnecessary risk to human health or impair the usefulness of the water. And so, because hydrofluorosilicic acid is a type of pollution that is, it's an unnecessary risk, okay? And so, I would argue that Henrico County is violating the Code of Virginia that requires pure water. They are violating the Virginia administrative codes, okay, because they are intentionally adding a type of pollutant to the drinking water that degrades the quality of water, and it constitutes an unnecessary risk. Sorry, guys, an unnecessary risk to human health. Okay, and it impairs the usefulness of the water for a lot of people. People who have kidney problems can't drink the water. If you have thyroid problems, you're discouraged from drinking the water. Pregnant women and babies are discouraged from drinking fluoridated water. So yes, you can't pollute the drinking water because it's unreasonable and it's unnecessary. You can get away with putting chemicals in the drinking water like chlorine because it's used to promote pure water. It's used to promote the potability. There is it, putting chlorine in the drinking water is a necessary risk. Putting fluoride in the drinking water is an unnecessary risk. It's just not necessary to put fluoride in the drinking water, and nobody can claim that it's necessary to put fluoride in the drinking water. If you want to ingest fluoride, then you should go out and get fluoride tablets, fluoride drops. If you want to be extraordinary crazy and dangerous and reckless, then go ahead and ingest, some toothpaste. But the same type of fluoride that's in toothpaste is in your drinking water. The same type of fluoride that's in toothpaste is in fluoride tablets and fluoride drops. Okay, they've been putting sodium fluoride in your drinking water for a very long time. That's a powder. Henrico has switched over to a liquid, which is hydrofluorosilicic acid. This is very similar. Okay, these are equally as dangerous. All right, so I think that covers everything I wanted to show you. Ask yourself, does the waterworks permit actually require the county of Henrico to intentionally pollute the public drinking water with hydrofluorosilicic acid? I think not, okay? And if you would like to go through and read these regulations in detail yourself, then you can look at Part 2 Operation Regulations for Waterworks. There's only 3 of them. Okay, guys? So we just touched on Part 2 Operation Regulations for waterworks, and you could see that none of those regulations require the county of Henrico to pollute the drinking water with hydrofluorosilicic acid, okay? And this permit says that and with the understanding that the owner will operate the waterworks in accordance with Part 2. Okay, so Henrico County is the owner, and they need to make sure that they are operating the waterworks in accordance with Part 2, which is Operation Regulations for Waterworks. The owner also must operate the waterworks in accordance with Title 32.1 of the Code of Virginia, and of course 12 VAC 5-590. And nowhere in any of these regulations does it say that Henrico County is required to pollute the drinking water with hydrofluorosilicic acid? Quite to the contrary, Virginia law requires pure water, which means you remove contaminations from the drinking water to make it safe to drink. You do not put FDA-defined drugs into the drinking water, okay? So I want to show you a few more things in this waterworks permit. Bentley Chan had mentioned that he was forced to put fluoride in the drinking water as a condition of the permit. That is not a truthful statement, in my opinion, by reading through Title 32.1. It also mentions in this waterworks operation permit that if there's special requirements, then it would be noted right here, okay? And there are no special requirements. So to put it plainly, I think it's fair to say that this waterworks operation permit does not require water fluoridation, and quite to the contrary, when you understand what hydrofluorosilicic acid is, the waterworks regulations would prohibit adding hydrofluorosilicic acid to the drinking water. Now, who issued this permit? Who signed off on it? That's going to be Virginia Department of Health's Office of Drinking Water, and it was J. Wesley Clean. Okay, so this is the individual who signed off on it. Now, this gentleman, Wesley Clean, he knew that Henrico County was going to be adding fluoride to the drinking water, and I want to show you the rest of this permit. So I'm going to show you the first page, and then we'll go further down below. Okay, so this comes from the Commonwealth of Virginia Department of Health, Office of Drinking Water, and this is the East Central Field Office. And up here in the top left corner, you can see who the state health commissioner was at the time. This is going to be Karen Rimley. I'm not sure if that's how you pronounce Karen's name, but Karen Rimley, okay? And this was also, again, Wesley Clean, and he was the director of Office of Drinking Water. He was the one that officially signed this waterworks permit. And who did it go to? It went to Mr. Arthur Petrini, I believe is how you pronounce his name, and he was the director for Henrico County Department of Public Utilities back in 2010. This was the last waterworks permit. It was updated in 2010. Okay, so again, they state on the very first page that essentially you're authorized by the state health commissioner to operate the public water supply at Henrico County, right? They're granting them permission to operate a waterworks. They're not granting Henrico permission to put drugs into the water. Whoops, sorry guys. And so then they go on to say part 2 of the waterworks regulations, which I believe we have exhausted that. And then the district engineer, Douglas E. Meyer, signed off on this particular document. Douglas E. Meyer. Okay. So this was sent PPC. I'm not sure what that means. And it says Henrico County Health Commissioner, Henrico County Manager, Henrico County Building Officer. I'm assuming this is kind of like CC, carbon copied. Okay, like this is who it went to. To put it plainly, I just don't know what PC specifically means. I've forgotten what that means. Okay. Let's scroll down below, because remember, the DPU director, he feels like he's forced to put fluoride in the drinking water as a condition of this permit. That is not true. We've looked at the permit, so he is mistaken, and I'm not sure if what's happening is a type of ignorance, or if this is, he knows what's going on and it's intentional. Sometimes it's a little bit difficult to jump inside people's brains to figure out if they're evil or ignorant. Okay, so let's move down below again. This waterworks permit, so they're given kind of more, they're given a description of what's going on. See, it's the description sheet. And the owner is going to be Henrico County Department of Public Utilities. The County of Henrico is the owner of this waterworks. And back in 2010, Mr. Arthur Petrini, the Director of Public Utilities, was the contact. He is not the owner, he's just the contact, okay? And so Henrico, the Virginia Department of Health's Office of Drinking Water knew that fluoridation was going to be done because it is listed right here in the description, type of treatment. Now, I find this to be dishonest because when they say type of treatment, you're thinking that they're treating water. They're not using fluoride to treat water. They're using fluoride to treat people, right? This is not to treat the water to make it safer to drink. It's used to treat the water. It's a type of mass medication. Okay, remember, this is an FDA defined drug. This is a recycled hazardous waste byproduct. This is a type of pollution. Okay, so if you go down, there's more description of the waterworks. So I just want to kind of show you what is on this document. If you would like to go through it in detail, you are welcome to pause this as I go along, or you can request a copy from Henrico County or Virginia Department of Health. Both entities have this document. Okay, I want to go further down to show you again in number 9, fluoride function, fluoride addition. Okay, so again on page 5, VDH knows that they're going to put fluoride in the drinking water, and then again down here on page 6 of 13, they say for the laboratory, the water treatment plant has a process control laboratory which can perform the following. It says not certified: temperature, pH, alkalinity, hardness, conductivity, calcium, and fluoride. So if you're going to be drugging the public, you should know what concentration you're drugging them with, but this is not certified. So it's not an independent lab. It's just what they're doing in-house, which is typical. And then it says the county has a more complete laboratory at the wastewater facility, which can perform the following. And again, they're going to be testing for fluoride. Okay, guys, so I want to move on to explain to you what is going on here. And I wrote something up that I hope will be helpful. So let's jump over to that. Okay, guys, I know that was a lot of ground to cover. So here are the key takeaways, okay? Defendants Waterworks operations permit requires the defendants to obey the law. That is the key point here, guys. Henrico County is required to obey the law. And in that waterworks permit, it said that the owner will operate the waterworks in accordance with Part 2 operation regulations for waterworks of the waterworks regulations of the Virginia Department of Health. And in that waterworks permit, they specifically said that this permit does not suspend, minimize, or otherwise alter the owner's obligation to comply with applicable federal, state, or local laws and regulations or permits. So the biggest point that I'm trying to make here, folks, is that Henrico County is required, they are obligated to obey federal, state, and local laws, and that this waterworks permit specifically highlighted Part 2 operation regulations. And in Part 2 of operations regulations for waterworks, specifically in 12 VAC 5-590-350, assessments and sanitary surveys paragraph A, it said, and this is very important here, folks, it said frequent assessments shall be made by the owner of the water supply and waterworks to locate and identify health hazards to the waterworks. So Henrico County is legally obligated to locate and identify health hazards to the waterworks. That's going to be health hazards to the waterworks operators and health hazards to the public. The manner and frequency of making these assessments and the rate at which discovered health hazards are to be removed shall be the responsibility of the owner. And every effort shall be made by the owner to the extent of his jurisdiction to prevent the degradation of the quality of water supplies. Okay, Henrico County, we have brought to their attention that hydrofluorosilicic acid is in fact a health hazard and it needs to be removed. Okay, so they have in fact discovered the health hazard. Why? Because we have shown them time and time again that this is a health hazard, and so they are legally obligated to do everything in their power to mitigate that health hazard. Okay, folks. And in 12 VAC 5-590-10 definitions and unit of measurement, they have a definition for pollution. And it says pollution means the presence of any foreign substance, chemical, physical, radiological, or biological in water that tends to degrade its quality so as to constitute an unnecessary risk to health or impair the usefulness of water. And remember, folks, water fluoridation poses an unreasonable risk. A federal judge has already determined that water fluoridation poses an unreasonable risk to the public, and doctors are now forbidden from writing fluoride prescriptions to children. So think about this, folks. If a doctor cannot give fluoride to a child, why are we allowing Henrico County to give fluoride to children? Okay, this is an unreasonable risk, and hydrofluorosilicic acid is in fact a poison. It is a pollution. It is a recycled hazardous waste byproduct. Okay, guys. And recall, both in the Virginia Administrative Code and the Code of Virginia, we have definitions regarding pure water. Pure water means water. Pure water means water fit for human consumption that is sanitary and normally free of minerals, organic substances, and toxic agents in excess of reasonable amounts, and adequate in the quantity and quality for the minimum health requirements of the person served. Guys, it is not reasonable to go out of your way to purchase a recycled hazardous waste byproduct, hydrofluorosilicic acid, and intentionally pollute the public drinking water with this. Remember, this is an EPA-defined contaminant. This is an FDA-defined drug. This is a recycled hazardous waste byproduct. It is not reasonable to put this into the drinking water because it degrades the quality of water. It is a pollution, and it also does not promote pure water. Hydrofluorosilicic acid does not promote the potability of water. It does not promote pure water. That is the key point here, folks. And then in part 2, section 12 VAC 5-590-360, responsibilities of the owner. Paragraph A, it says preventive control measures identified in Part 2 of this chapter shall be promptly implemented to protect public health. Okay, so it shall be promptly implemented. I believe that Henrico County is violating state law and is violating the regulations, the Virginia Administrative Code. So, in conclusion, we have defendants intentionally polluting Henrico's public drinking water with hydrofluorosilicic acid, and VDH officials knowingly enabled or ignored said conduct. I have provided 3 examples to help illustrate how serious this matter is. I provided 2 analogies and 1 controlled response. So let's jump into it. Defendant's position has been somewhat analogous to a car salesperson who enthusiastically recommends that a customer buy a car to speed 100 miles per hour down Midlothian Turnpike. The customer likes the recommendation, buys the car, and is later cited for reckless driving. It would be no defense for the customer to argue, the salesperson recommended it and then sold me the car, right? That would be an absolutely moronic defense. The salesperson's recommendations did not change the law, and the sale of the car did not authorize unlawful conduct. Okay, just because a salesperson recommended the car and sold the car does not magically make it lawful. Likewise, even if the Virginia Department of Health recommended community water fluoridation and issued Henrico County an operation permit with knowledge that Henrico intended to fluoridate, neither the recommendation nor the permit altered Henrico's independent obligation to comply with Virginia statutes and waterworks regulations. A recommendation is not statutory authority, and an operation permit is not a license to disregard the law. Second example I wrote up for you, this response is going to be much more controlled. So I wrote, defendants cannot avoid their independent legal obligations by pointing to the Virginia Department of Health's issuance of an operation permit. The permit itself expressly provides that it does not suspend, minimize, or otherwise alter this owner's obligation to comply with applicable federal, state, or local laws and regulations or permits. Accordingly, Henrico County remained legally responsible for ensuring that its operation of the public waterworks complied with all applicable state and all applicable statutes and regulations. If the Virginia Department of Health erred by issuing a permit for a system that unilaterally operated in violation of Virginia law or the waterworks regulations, that error does not relieve Henrico of its independent duty to obey the law. Likewise, even assuming the Office of Drinking Water knew Henrico intended to fluoridate when it issued the permit, such knowledge could not confer legal authority that the General Assembly did not grant, nor could it excuse non-compliance with governing statutes and regulations. An administrative permit cannot authorize conduct that the law itself does not authorize, and Henrico cannot shift statutory responsibilities to the agency that issued the permit. Okay, so in other words, if Virginia Department of Health made an error by issuing Henrico County a permit when they intended to pollute the water, that doesn't protect the county of Henrico, right? It doesn't matter how many mistakes Virginia Department of Health makes, whether they're intentional mistakes or whether they're legitimate mistakes. VDH's mistakes do not protect the county. Henrico County has a legal obligation to follow state and federal laws. Okay, guys? And remember, there is no state law that authorizes water fluoridation. So just because Virginia Department of Health hands out permits and says go ahead and fluoridate, that does not protect Henrico from their responsibility to follow state laws. Virginia Department of Health cannot grant Henrico County authority that the General Assembly did not authorize. Okay, guys, so that is what is important. Finally, just as a little bit of a side note, to this day, Henrico County has not identified the official who is legally responsible for continuing Henrico County's water fluoridation program. So here, just so you can know, I said, please provide the record that identifies the Henrico County official who is legally responsible for continuing Henrico County's water fluoridation program. And Henrico County for 2 years, something in that range, 2 years, they keep saying we don't know who is legally, we can't identify the official who is legally responsible for continuing Henrico County's water fluoridation program. Guys, this is absolutely egregious. Okay, guys, this is my third and final example. It is an analogy. I think this analogy really highlights the problems that's going on here in Henrico. So let's go ahead and jump into it, shall we? Here we go. Henrico County's position is analogous to a mother who walks into a liquor store with a fussy, teething baby on her hip. She asks the cashier for advice, and the cashier recommends adding liquor to the baby's bottle mixed with juice, saying, "A drunk baby is a quiet baby." The cashier then helps her select a bottle and sells it to her. The mother goes home, prepares the mixture, and gives it to her child. Later, she's arrested and charged with child endangerment. Bewildered, she protests that the cashier, in apparent authority, recommended the practice and facilitated the purchase. The mother insists that she cannot be held responsible. You see where I'm going here with this, guys? Virginia Department of Health is recommending that the county of Henrico pollute the public drinking water with hydrofluorosilicic acid. And then, after making the recommendation to pollute the public drinking water, Virginia Department of Health then proceeds to sell the county of Henrico a waterworks permit. Now, Henrico County is bewildered as to what the problem is, because the apparent authority, Virginia Department of Health, was the ones that recommended polluting the drinking water and then facilitated in the purchase of the permit. The judge rejects this defense. A sale and a recommendation does not override the law. The fact that someone recommends or assists in an act does not, in fact, make it lawful. The mother had an independent legal duty to protect her child. She cannot escape legal responsibility to care for the child because she chose to defer to the cashier. Likewise, guys, Henrico County cannot escape their legal duty to provide pure water by deferring to Virginia Department of Health. Henrico County's reasoning follows the same flawed logic. The county argues that because the Virginia Department of Health recommends community water fluoridation and issued a waterworks operations permit, Henrico's continued addition of fluoride to the public water supply must be lawful. Guys, under this view, a recommendation and a permit can become a complete justification for any unlawful act. This is absolutely asinine. Imagine if somebody recommended that you operate a restaurant out of your garage and then gave you the permit to do so. That doesn't magically make it lawful. Recommendations and permits do not magically make the conduct lawful. But a recommendation is not a statute, and a permit does not create legal authority where none exist. A permit can only authorize what the law itself permits. If the underlying law does not authorize the action, neither the recommendation nor a permit is sufficient to engage in the challenge conduct. Just as no law or recommendation authorizes a mother to feed alcohol to her baby, no recommendation or permit can authorize a local government to intentionally pollute the drinking water with hydrofluorosilicic acid and deliver it to the children of Henrico. Recommendations and permits do not legalize conduct the law clearly forbids. They do not transform unreasonable or dangerous practices into lawful ones. And recommendations certainly do not excuse actions that place the public, especially children, at risk. Henrico County has an independent legal duty to protect its residents. It cannot evade that duty by sheltering behind an ill-advised recommendation or permit any more than a mother can avoid accountability by pointing to stupid advice from a cashier. Guys, water fluoridation poses an unreasonable risk of injury. Hydrofluorosilicic acid is a type of toxin. This is a pollution, and the law does not authorize Henrico County to pollute the public drinking water with this chemical. This is, in fact, unreasonable and unlawful, in my opinion. And that is all I have to say about that. All right. Well, there we have it. What do you think? Does the Henrico Waterworks permit force the county to pollute the public drinking water with hydrofluorosilicic acid? Was the Department of Public Utilities Director Bentley Chan telling us the truth when he said that the permit forces him to put fluoride in the drinking water? I think not. I think that the county of Henrico, it has been bamboozled by the Virginia Department of Health, and now they are deciding to collude with those who want to mass medicate us. But what do you think? I want to hear from you. Make sure to leave a thumbs up, hit the subscribe button, leave a comment below, and I will see you next time. Thanks, guys. Thanks for joining the Granite Files.